Welcome to Witch Draft. This is Jason Mark Anderman. Today we're going to take a look at a mutual non-disclosure agreement. And this particular agreement is designed for the situation where the two parties to the contract are going to be exchanging confidential information with each other. And what you really want to do is make both parties feel pretty good about that exchange and that their confidential information will be protected by each other. So what's the first thing you're going to nail in this kind of an agreement? The first thing you're going to take a hard look at here is the business purpose, and that's pretty much something you put up front here, and you just kind of say, hey, this is the business relationship that we're considering with each other. In this case, for instance, I wrote developing a contract training video because that's what we're doing right here that you're listening to. And you just want to spell that out so people have a good idea of what the purpose of the confidential information exchange is. The next thing you want to then take a look is defining your confidential information. And you want to make sure that when something gets disclosed by the disclosing party to the receiving party, it could be either one since this is mutual, whether or not the information is going to be marked is a really important issue. And a marking requirement basically says that you're going to stamp the confidential information or include a legend at the bottom of it that says this is confidential or proprietary to me. And this would be a marking requirement that's written here. If you don't have a marking requirement, then what you normally say is pretty much everything that I give you, just deem it as my confidential information. There are going to be certain exceptions to that that are spelled out expressly later in the contract, but that's a good way to go, especially if someone has wide-ranging access to your information and it's going to be on site on your premises. The next thing that you're going to think a lot about here is what's going to be excluded from this definition of confidential information. What if that I give you, even though it's my information, you don't have to treat as confidential. And usually that's going to be three things. That's going to be information that's already out there in the public. That's going to be information that you might happen to have that's exactly the same, but you independently developed it without referring to any of mine. And the last thing would be is if you rightfully receive the same thing from a third party, some other company out there who, I guess, independently developed it or got it in the public domain. What are the exact duties you have to follow? Well, both parties are going to respect each other's confidentiality by making sure that they don't disclose it to any third party. They keep it only to employees in their company. And they only let those employees use it as necessary to perform contractual obligations to the other party or engage in the activities contemplated under the business purpose. And this is why you spelled out the business purpose earlier. You want to make sure that they advise all their employees of these confidentiality requirements, and you want to make sure whether or not you decide they can disclose it to their third-party agents and their third-party subcontractors who are helping them out or performing services for them. In that case, if you do let them do that, you might want to say, hey, you got to make sure that those people sign a subcontractor confidentiality agreement that similarly protects my confidential information. You want notice as soon as they find out of any breach of confidentiality, and whenever you tell them to return it to you or whenever the agreement ends, you want to make sure that you get it returned. Also, if for any reason they are required to disclose this information by law, you want to make sure that they give you notice of it and time to apply to the judge for a protective order so it doesn't get disclosed to the public. You'll spell out how long the term will be. If you're not sure, it's a good idea to just do a one-year term, and then you might have it automatically renew unless you give notice that it doesn't. That way you make sure confidentiality is still running for future disclosures. A lot of times people forget about that. And that pretty much sums up the kinds of issues that you'd care about. The only other thing you might think a little bit about here is having a termination for convenience clause. And that's basically a clause that says you can get out of the agreement at any time and terminate it and get your confidential information back. You might want to have that if you're just not sure how long you're going to be exchanging confidential information with each other and you just want a nice way to wrap things up. That's a mutual confidentiality agreement and how it pretty much works. Mutual non-disclosure agreement is another name for it. Thanks for listening and have fun using Witch Draft.